I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my stunned co-host, Brett.
Stunned, Alice. Always stunned. Always really feeling in awe right now, basically.
As you should be, Brett. We are all stunned to be in the presence of Erlinda Ocampo Johnson. You may have heard her name a lot recently, and that's because she was the prosecutor on the Alec Baldwin prosecution, who actually, very famously on the last day of trial before the judge dismissed the case, resigned from the case in protestation. We are so excited to have you with us, Erlinda. Thank you for joining us.
Well, thank you for having me. I appreciate it.
Well, Erlinda, I know that the people who are watching right now, their questions are already going to be flying off the handle. But before we kind of get to the most recent trial you had involving Alec Baldwin and the tragic death and shooting that happened on the set of a movie, we'd love to hear a little bit about you and your background and what kind of law you've practiced leading up to this special appointment as special prosecutor in this case.
Oh, sure. I'm actually originally from Central America. I'm an immigrant to the United States, so English is my second language. And I was raised in Santa Fe, New Mexico. And I started my career in the law as a state prosecutor in Albuquerque, New Mexico. And then I went over to the U.S. Attorney's Office. So I was a state and federal prosecutor for about a little over 11 years. And then I went into private practice, mainly out of necessity because I had a young child and the U.S. Attorney's Office would not allow me to work part-time so that I could be at home with her when she got out of preschool. So I had to go into private practice. And since criminal law is all I knew for over 11 years, I started doing criminal defense. And I've been doing criminal defense now for over 16 years. And then at around mid-April, early April of this year, I was contacted and asked if I would be willing to be one of the prosecutors on the Alec Baldwin involuntary manslaughter prosecution. It was really late in the process. Trial was scheduled for July 8th, July 9th. And so since I was kind of starting to wind down my practice, not necessarily to retire, but just to be more selective about the cases that I took, I thought, this would be a great opportunity to go back to where I started, go back to my roots, because I loved being a prosecutor. I really enjoyed it. And I thought this would be a great opportunity to go back to that. And also because a woman was killed. And the way I saw this case was the facts need to be determined by a jury. Just present the facts to a jury and let the jury decide. So I said, okay.
There's so much to unpack there. Wow. First of all, as a child of immigrants who English was not her first language and practicing in, a field where there's not a lot of us who grew up like us, you are such a hero in my mind. And I think the more that people hear about you, you are going to be a real role model to a lot of people who aspire to be lawyers. So thank you, first of all, for speaking about your background. But leading up to that April call that you get, a lot of people who follow true crime cases know that typically prosecutors are with the case from the beginning. They're either part of the investigation or they certainly help indict the case, and they are usually employed by the state. You are none of those things. You were not part of the initial investigation, and you were not employed by the state at the time. So can you talk a little bit about why they needed you at this juncture and how this would even work in terms of appointing a special prosecutor who is not working for the state?
Sure. So it turns out that the Santa Fe County District Attorney's Office either had a conflict or actually chose to give both the Armorer's case and Mr. Baldwin's case to special prosecutors so that they could devote all the time necessary to the cases, because apparently it's a small, Santa Fe County DA's office is a small office, and they couldn't devote the resources and take prosecutors away from their regular caseload to just devote the time to this case. So the Santa Fe County DAs, or DAs actually throughout the state, have the power under statute to appoint attorneys in good standing to work as special prosecutors in a specific case. And that's how I was appointed by the Santa Fe County DA to be a special prosecutor on the Baldwin case only.
So when you come into the case, one of the advantages of being with the case from the very beginning is you're already familiar with the evidence and how it came in and what I was out there. And some of that's going to become important later on. But what was it like diving into a case that you had to know was going to attract a lot of attention? There was going to be a lot of scrutiny on it. You were going to be up against some really good, high-priced, high-powered attorneys. What was that like, and how did you approach that challenge?
You know, it was challenging because, as Alice mentioned, when you're a prosecutor, particularly as a federal prosecutor, you're assigned to a case when it's still in the investigative phase. Agents are calling you for advice on certain investigative steps. And so you know pretty much everything. And that's why I enjoyed being a federal prosecutor, because you're with the case from beginning to end and you know everything about the case. In the Baldwin case, and now actually that is a regret that I have, is actually stepping into this case so late in the process. So much had happened on the case that I was not privy to or became aware of, or actually, as you all know, I became aware of something very big on the day I asked to withdraw and resign from the case. So there was over a terabyte of discovery on the case. And so I started reviewing the discovery. What I was given, I had 2 external hard drives with discovery from the case. But I didn't review anything from the Hannah Gutierrez Reed trial. In fact, I didn't follow this case. I didn't follow it in the media. I didn't follow the Gutierrez trial at all. And so I was focused on getting up to speed on this case. And I thought, okay, I think we're okay. We got a grasp on the evidence, on the issues. And I spent most of my time actually researching and writing motions, responses to motions. As you all know, there were numerous motions that were filed by the defense on the case. And so I spent a lot of time doing that, which took me away from discovery review. So it was quite challenging. And in retrospect, you know, something I would not recommend an attorney do is to step into a case that far into the process and really not know your co-counsel that well.
And of course, when you say the Hannah Gutierrez case, that was the armorer who, at this point, when you stepped in the case, I think had already been convicted. Is that correct? And so,
That's exactly right.
and I love what you just said, that you hadn't really followed this case in the media, because oftentimes we hear people say, if a case is in the media, how will you possibly have a jury that can be sat who's never heard of the case? Or how can anyone be untainted from what the media said?
Mhm.
And you're a great example. This is your area, and you're even literally geographically in the area. But this was not a case that you followed closely until the discovery quite literally dropped in your lap in the form of 2 external hard drives. And thank you for giving us that background of truly what it's like to receive and go through all this discovery, and how much of really preparation is not what you see on TV in court, but rather the reading, reviewing, researching. And when you say that you had a co-counsel, can you talk a little bit about that? Was your co-counsel also appointed, and at what juncture in the case?
So she was the lead counsel. She was the lead prosecutor on the case. I believe she was appointed in January of 2023. And so she was asked by the Santa Fe County DA to step in and work as the lead prosecutor on the 2 cases, Baldwin and the armorer, Ms. Gutierrez. And so she had been with the case pretty much very early on. She's the one who actually presented Mr. Baldwin's case to the grand jury. She initially dismissed the pending indictment back in 2023 and then went back to the grand jury in 24 and presented it. So she had had a lot of time. And of course, she's the one who did the trial of the armorer, which I did not follow. I was too busy with my caseload.
So you walk into this trial and you have what I still believe is the most important thing that happens in a trial, which is the opening statement. You're going to lay this out for the jury. You're the first voice they're going to hear about what happened. Talk a little bit about how you approach that and how you try and craft an opening statement to make that initial impression on the jury.
Well, for me, and if you noticed, I objected a lot to the defense opening statement because it was more of an opening argument. And actually, I teased him afterwards. I said, nice opening argument. And so basically, my focus was on the evidence and the evidence that I believe that we had. And I still believe that there was evidence of recklessness on the set, and particularly recklessness that I believe on the part of Mr. Baldwin. And so I just focused on the facts, on the evidence that I believe we were going to be able to present during the trial that would show a essentially wanton disregard for safety of others in handling a firearm. And I knew it was going to be, we had some challenges, and I think I tried to incorporate those in my opening statement about the gun having been destroyed or damaged at the FBI lab. One of our experts actually opining something last August of 2023, and then subsequently after he spoke with the FBI analyst, modified that opinion, and obviously that was going to come out, so I addressed that in my opening. So I figured just put it all in front of the jury, and the jury may have acquitted, very likely, and that I would have been fine with that too. I mean, I wasn't there to secure a conviction. I was there to just present the evidence, because at the end of the day, a woman lost her life in a very violent way. And so a jury needed to decide who was culpable and who was not.
And now, leading up to trial, as would be expected, Mr. Baldwin's attorneys filed multiple motions to dismiss. I think they challenged evidence. And I say you would expect this because, he has good counsel. He pays for his counsel. And you're always going to try to get rid of a case before it goes to trial without a conviction, right? And obviously those all failed because the case did go to trial. And we're all here right now because something came to light that you did not previously know about, which was absolutely game changing for this case and for any case. So can you describe to us what happened that utterly changed the course of this case?
So Thursday afternoon, Mr. Spiro, the lead defense counsel, is cross-examining the crime scene technician, and he's asking her about some ammunition that was taken to the sheriff's department by a good Samaritan. And I'm thinking, well, this is kind of, where is he going? This is ridiculous. What is he talking about? And so he's cross-examining her about how this Good Samaritan allegedly made representations that this ammunition came from or was similar to the live ammo that was found on the set of Rust. And where was this ammunition? How come it had not been made available to the defense? He kept using the word voucher, which here we used inventory. So why was it inventoried under a different case number? Why wasn't it placed with the evidence for the Rust investigation? And so at some point, light bulbs going off above my head. I'm thinking, wait a minute. What is this? So I'm writing little notes to the folks at my table asking, what is he talking about? And somebody says, oh, it's some ammo that Troy Teskey surrendered. And I said, who's Troy Teskey? So at that point, I'm like, oh my God, what is happening? And so this was late in the afternoon. So after we recessed for the evening, the investigator and my co-counsel explained to me who this individual is and what happened. He brought this ammo. And I said, why wasn't it turned over to the defense, or at least made available to the defense? Well, it's not relevant. It's not relevant to the defense. It's just not at all. And I said, well, I don't think we get to make that decision. And my co-counsel was also a criminal defense lawyer. So I was actually a little surprised, because I said, prosecutors don't get to make that call. What the defense is going to be, that's for the defense to decide.
And just so we understand your thinking process, who was Troy and what was he turning over that made that light bulb go off in your head? Because you're right, not everything is included in a case file, but what about this particular witness who turned over ammo made the light bulb go off in your head?
So Troy Teskey, from what I learned, was a friend of the armorer's father. And so the armorer's father had been on the set of another movie in Texas, 1883, with the guy who supplied the props to Rust, the guy by the name of Seth Kenney. So they had live ammunition in Texas. Both the armorer's father, Thel Reed, a well-known armorer himself, and Seth Kenney had live ammo on the set of this other movie in Texas. Then they left. They came to New Mexico, and Thel Reed, I think, was going to Arizona, but Seth Kenney kept some of the live ammo. And so part of it then ends up with Thel Reed, but Thel Reed has Troy Teskey basically store his ammo or the ammo in his garage. So Troy Teskey grabs some of this ammo and says, these rounds are similar to the ones found on the set of Rust. And either they came from Seth Kenney or, there would have been that, I think, impeachment of Mr. Kenney that, hey, you had live rounds that ended up with Troy Teskey. So Troy Teskey was called as a witness by the armorer's attorney, but then at the last minute, he didn't testify. So he shows up at the Hannah Gutierrez trial and he brings part of this ammo. And the attorney says, I don't want it. I don't need you. I'm not going to call you. So Mr. Teskey then goes over to the sheriff's department and says, I have evidence. I have evidence that is relevant to this Rust case, and it may be rounds that are similar or part of the rounds that were found on the set of Rust. So now I'm thinking, when I'm learning this, the defense is probably going to argue Hannah Gutierrez was a phenomenal armorer. She was extremely competent, and somebody sabotaged her. And that someone is probably Seth Kenney. And so that's where these live rounds that Teskey turned in would have come into play for possible impeachment of Seth Kenney. And so I'm telling my co-counsel, this is not good. This is a violation. These should have been made available to the defense. And we're in the middle of trial. I think at this point, the only right thing to do is to just walk in there and dismiss.
And all this is happening Thursday night when you're having this conversation?
Yes, and Friday morning.
So initially, Thursday night, I guess you leave that meeting at least thinking I'm going to go in there tomorrow and sort of continue to argue the case.
Right.
What was it that changed between sort of the way things were Thursday night and then what happened on Friday that led you to think, I only have one option here?
Well, so Thursday night, I'm thinking, oh, these rounds don't look anything like the rounds found on the set of Rust, the live ammo, because remember, there was live ammo. That was 5 rounds of live ammunition that were found on the set of Rust. So what was explained to me was they look nothing like what was found on the set of Rust. They're completely dissimilar. I thought, okay, well then, all right. So then Friday morning, the judge orders that the little bag that contained the ammo, be brought into the courtroom. And if you recall, she puts on the gloves and she opens the envelope and then starts asking the crime scene technician to remove the bullets from the evidence bag, basically by categories. And so at some point, 3 bullets come out that look very similar to the bullets that were found on the set of Rust. So the others did not, but 3 almost identical. So at that point, in fact, I remember I made eye contact with lead defense counsel, and I think we both had like, oh my God, kind of that moment. It was at that point that I thought this should have been disclosed.
And so that was the first time you ever actually saw the ammunition. Is that correct?
Exactly. I'd never seen that before.
And, we talk about this a lot as well, which is that, discovery, you're responsible as the prosecutor for all the discovery that anyone who investigates under you has. Do you know, had anyone else on the prosecution team seen that before?
Now, co-counsel said she had not seen them either. So, but she was aware. And I think that the issue was that she was aware that they had been turned into the sheriff's department, and she was involved, according to the testimony, in the decision-making for basically placing them under a separate case number.
I understand. Okay, so then there's 2 potential options. I know what ultimately happens, but when you have either late discovered evidence, whether it's because nobody knew about it, let's say you just literally found it behind a shed, versus you didn't know to turn it over. Those are two slightly different things. But in some cases, if there's late discovered evidence, the one way forward is to turn that over, maybe take a recess, regroup, and then continue to argue the case now with the newly discovered evidence. And then the other path, of course, is to either argue for dismissal or for the prosecution to dismiss. So why in this case was it not the former, where, oh, we didn't know to turn this over, let's turn it over, let's try to cure as best as we can, whether it's a recess of a day, a week? What was different about this particular instance that couldn't be cured just by turning it over even late in the game?
Well, I think because one of the issues was some of this ammunition that had been found on the set of Rust was sent to the FBI for analysis. The explosives unit analyzed the powder to determine whether or not it was consistent with rounds that were found in Seth Kenny's business. So there was this period of time, and of course, they need time, as you all know. I mean, they can't just turn it around in a week. We're in the middle of trial. Jeopardy has attached. And so there's no way that we would have been able to say, Judge, can we have a recess for about 4 weeks so the FBI can do its analysis? And that was something that obviously, to me, it was Jeopardy's attached. We're in the middle of trial. There's no way that we can ask. It's not like something that the defense can just take a day or two to review. It is something that required, I thought, further analysis.
So you're at this point now where curing isn't an option, sounds like. It's not something that can be cured. So either you have to convince the judge it's not material and it's not relevant, or it's going to be dismissed either by you or by the judge. And it sounds like your co-counsel wanted to fight it out, and in fact did end up fighting it out. And I think there's a tendency amongst prosecutors, and really, I guess, amongst most lawyers, to sort of never admit error and basically just say, hey, my job's to fight. They can fight. If the judge wants to dismiss, they can dismiss. What was it that made you think, no, I have another obligation to do what I think is the right thing here and not wait on the judge to make the decision?
So, and you're absolutely right. There was a disagreement. My former co-counsel believed it wasn't material and she was going to fight it out. I believed it was. And when I was a prosecutor, I used to turn over more than was required. As we all know, Rule 16 is not very defense friendly in the federal system. But I was the opposite. I mean, when I had wiretap cases, because I prosecuted a lot of drug trafficking cases, I turned over 10-day reports, even though we're not required to. I mean, I turned over a lot of stuff that just we weren't required to. But I thought, then we'll fight it out in court over what comes in, what doesn't come in. That's kind of the exception. I don't think, and I was a tough prosecutor, but I always was of the idea, let's just turn everything over and then we'll go hash it out in court. And so that, for me, it was just a personal decision. It was just, I read the case law. I believed that it was material. And at that point, it's so late in the game. There's no way that we can ask for a 4-week continuance, Judge, since the jury's already been seated, because that's what we remember. And keep in mind, too, there had been some other motions with regard to evidence that was either turned over late. That expert report that I had mentioned earlier sat in my former co-counsel's inbox for many months. I didn't know about it. I learned about it during a pretrial interview with defense counsel, and then it was turned over, and she said, well, it just sat in my inbox. I forgot about it. I was like, okay, well, we're a couple months from trial. That's fine. Okay. Then there was an Inspection of Public Records Act production that had been made by the DA's office that was redacted almost in full. And I, about probably 10 days before the trial or less, an investigator and I went through it, and we started unredacting stuff that should have been turned over, like statements by expert witnesses. And so we turned over about over 1,100 pages. And this is a week before trial. So at this point, I'm thinking, okay. And I think that that probably factored into the judge's analysis too. This is just too much. And I personally, maybe other prosecutors would probably disagree with me. And actually I've received some very nasty emails from people saying, that I shouldn't have done what I did. But I personally just thought that was the right thing to do. And sometimes you just bite the bullet and say, I move to dismiss.
You are describing the ultimate professional quandary for any attorney. You said that you studied the case law, and in your mind, there was no argument that this wasn't material. And so once you have reached your professional judgment that this failure to turn over evidence, which by the way is called a Brady violation, incredibly serious, is material, and we all know that we are bound by the professional rules of conduct. We take oaths to always have candor to the court. And especially, we talk about this a lot, whether it's fair or not. I think it is fair. When you are in the position of a prosecutor, you are held to a higher standard. At all times, you are supposed to pursue justice. And like you said, you're not there to pursue a conviction. So when you have these two truths before you, there has been a material violation, and you have sworn yourself to abide by these ethical rules. People often ask, what do you do next? There is one textbook answer, and it's what you did, which is to resign. But very, very few attorneys do this. Can you walk us? I've never had to face that decision. Can you walk us through, as you made this realization, did you have a conversation with your co-counsel, and how did it come to be that you literally walked up and resigned?
So I did during the break because I requested a break. She requested a break, and I wanted to talk to my co-counsel about, hey, this is what the case law says. I think the right thing to do is to dismiss. Just walk in there and say, Your Honor, given what has developed, the state will move to dismiss. She wanted all the facts to come out. She said, I don't think it's material. I think the public deserves to know what happened. I didn't intentionally, and I don't think she intentionally withheld evidence. The reality is it wasn't turned over, but my recommendation failed. So we walked back into court. I was a little bit late. The judge was already on the bench, and she had already said, call your first witness. So I was forced to sit down. But in my mind, as my co-counsel is doing the direct exam of, in fact, Seth Kenney, I'm thinking, this isn't right. I had this gut-wrenching pain in my stomach, and my ears kept ringing, and I just kept thinking, this isn't right. This isn't right. I don't believe in this. I don't believe in this. So when she finished her direct, it was at that point that we asked to approach, and we approached the bench. And that's when I asked the judge to allow me to withdraw from the case. And I made very clear, I said, as an officer of the court, Your Honor, I had no idea about any of this. I'm asking you to please allow me to withdraw from the case. And the judge looked at me, I think, with eyes of compassion. I just remember, because I remember my eyes were just welling up with tears, because it was so emotional, because I just kept thinking, this isn't right. I don't care who's watching. The right thing to do would have been to dismiss this. And so she allowed me to withdraw, and I left. It's just one of those things that you just know it's not right. You read the law, and at some point, as a prosecutor, like you said, you are held to a higher standard. I mean, as defense attorneys, you're expected to be zealous. You're expected to go in there and fight till the end. But as prosecutors, that's just not the role. It's not easy.
I was going to ask the surprise element. So obviously, when you approach the bench, you do so with both sides counsel there. And so defense counsel is hearing you say this. Your co-counsel is hearing you say this. You described the judge's reaction. What was the reaction of the other attorneys as you said this?
My former co-counsel, I think she said, Judge, I can't prevent her from withdrawing. And when I said I had no idea about any of this, Your Honor, this is this evidence that was not turned over. And she actually said, she's correct, Your Honor. Ms. Johnson had no idea, did not know about any of this. And defense counsel said, well, I guess I can't object. And he said, because, she's part of this. He initially was like, well, she's part of the state. But then when it was clear that I did not know about any of the evidence that was withheld. And he said, well, I don't object. And I don't honestly wasn't looking to see what their reactions were. But for me, it was like, this is the right thing to do. When I just blurted out and I told the judge, Your Honor, I've moved to withdraw from this case. I'm asking you to allow me to withdraw from this case. It was like just like a weight was lifted off my shoulders.
And I think, one reason I think a lot of prosecutors would have a really tough time in your shoes, and I'm sure you felt this, is not so much, well, I don't want to lose, I don't want to admit I'm wrong, but we always carry the weight of the victims with us. Like, we always want to do justice for the victims. That's why we're in this game, right? And that's why we do what we do, is because we want to get justice for victims. How did that weigh on you as you're going up there and you realize, I want to get justice for Helena Hutchins, but something has happened that's going to prevent that from happening, from being able to happen? How did that weigh on you?
I felt terrible, and I think that was one of the reasons why I was so emotional too. When I walked up to the bench, and my eyes were just filling up with tears, because I thought, this is why I actually agreed to take this case, because this woman was killed. There was a woman who was dead. There was a little boy who doesn't have a mom. And, as prosecutors, you want to do the right thing. You want it. But at the same time, you've got due process. You have the Constitution. You have obligations that, in this case, were clearly not met as it relates to that particular piece of evidence. So it was very emotional. It really is. Like I said earlier, when I was reading the transcript today of that bench conference, I started crying, because it was just, I feel like, that we did let Helena Hutchins and her family down.
And so obviously you then left the courtroom at that point, but the hearing continued. We now know from watching the news what happened, but will you kind of just finish out what happened with the rest of the case, even though you weren't in the courtroom anymore?
Sure. So my former co-counsel, continued with the hearing. I believe she presented the testimony of the detective. I don't think the crime scene technician testified again, of the detective, because I still have not watched the full. I don't have the heart to watch the full hearing. I've just have seen little clips of what happened. And then obviously the judge, and then my former co-counsel decided to take the stand. Oh my God.
You ever seen that happen before?
Ooh.
No, never. Have you guys? I've been doing this 28 years.
It's my worst nightmare to have to take the stand if I'm a prosecutor on the case.
I was like breaking out in hives watching that happen.
Oh my God. Well, I knew in the morning before the judge took a break, there was a bench conference. So I was reading the real time, and my former co-counsel is at the bench with Alex Spiro, the lead defense counsel, and she's saying, Judge, I think we need to have a hearing, and I may need to testify. And then the judge says, what? You need to testify? She says, yes, I think I'm going to need to testify. And then the judge says, well, then I guess Ms. Johnson will have to question you. And I remember sitting there going, no. Bad idea. Oh God, please. And, at that point, the judge hadn't opened the evidence bag, and I hadn't learned what I later learned. But yeah, that was, oh my God, that's what I watched bits and pieces of. That was very ill-advised. I've never seen it in 28 years. I've never seen a prosecutor who's prosecuting a case take the stand in the case he or she is prosecuting.
Again, it's my worst nightmare that I'm somehow subpoenaed to testify in my own case. And we explain this to people all the time. That's why when we are part of an investigation, we never are the sole questioner. We always have an agent or law enforcement there with us so that we don't have to ever take the stand. Okay. And so the hearing concludes, and the judge agrees with you, right?
Yes. She finds that there was a violation that prejudiced the defense. And so she dismissed the case with prejudice.
And what was interesting about that to me, and I don't even know if you've seen how this went down, but your former co-counsel gets off the stand and the judge asks, does anybody want to make any arguments? And both sides are like, no, I think we're good. And then the judge already has her sort of opinion ready to go, which I think speaks to how obvious it was to the judge that you were right, that this was a very clear case where it's obvious there's been a violation, and the only remedy is dismissal.
Right.
And of course, you've already mentioned this, for those who may not be as familiar with the legal system, once the jury is seated, jeopardy attaches. And obviously, under our Constitution, there's no double jeopardy. And so that's why this was so important. A lot of people have been a little bit confused. Why not just dismiss, bring it again? It happened one time. And there's a difference here, right? There's a reason we have protections of double jeopardy. And I mean, the judge obviously knew how she was going to come out, but have you ever resigned from a case in the same manner or seen anyone who's resigned from a case in the same manner before?
I have never. I have never resigned from a case in that manner. I mean, I was a prosecutor for a little over 11 years, and I never resigned in the middle of a trial. And I tried a lot of cases. And it just was one of those where my conscience, my ethics, my morals, everything was in play. And at that point, I thought, I don't care who's watching. I don't care if this is the biggest case of my career. I don't care. This isn't right. And I'm going to ask to step down. I can't do this.
Let me ask you this. We're fortunate to have a lot of young lawyers, law students, future prosecutors listening to this show. What advice would you give to them, either what you learned from this case or what you've learned over your career about how to do this job with the same respect for the rights of the accused as you showed in this case?
Well, first of all, don't jump into a case so far into the process as a prosecutor, and sometimes you are assigned to help out another prosecutor to go to trial. But, I think that at that point, you have to make sure that you err on the side of full disclosure, get everything out. And if something isn't right and it isn't right, don't sit there and just not do anything. You have to make the right decision. And I think always just remember, people will say what they want about you. People will talk and, people will criticize, but your character. And if you live by your word and you live by your fundamental beliefs. And I think it comes down to also to morality. I mean, I know that, a lot of people say, well, that's different than, what our professional ethical responsibilities are. For me, they are not. I just think that if something isn't right, and especially as a prosecutor, and if you're not playing by the rules, and you just have to make those tough decisions. As a defense attorney, I think also, and I'm a zealous defense attorney. As a defense attorney, same thing. I mean, if you have something that you want to present evidence, I always check and double check. I'm like, so you're telling me that this came from where? If I'm going to present it, I want to make sure that it's something that's legitimate, because there are situations, and I've had situations in the past as a defense lawyer, where somebody says, oh, what about if you present this piece of evidence or this defense? And it's like, well, is there something to back this up with? Because the prosecution's going to be investigating and is going to be looking into it. Is this factual? Is this true? And so you always have to do that balancing. But as prosecutors, there's that higher standard that prosecutors are held to, that you have to be extra, I think, careful and completely transparent.
And I know we're getting to look at all this with hindsight 2020, but truthfully, all of the personal, struggle you had it wasn't a struggle for you. You ultimately chose the right decision. You didn't know that you were going to be vindicated in the end. You were walking away from probably the most high profile case that you'd ever done, just by virtue of the famous name behind the prosecution. And it could have, in a lot of people's eyes, been a terrible career move or what have you, to walk away from the largest case that's all over the media. But it is amazing to see someone make the difficult decision that is absolutely morally and ethically correct and be vindicated. So for you, I'm really glad that you were vindicated so quickly. But I'd like to remind everyone who's listening now, that wasn't the case when you made the decision. You had no idea how the rest of that day would go.
Right. And I was okay with it too, because I knew when I made that decision that the judge could have said, well, this is not material. So defense, I'll give you a couple of days to, it's Friday, we'll resume Tuesday. I was okay with it. I was okay that I was not going to be part of that case if the judge denied the defendant's motion. To me, I did what I felt was right, and the law stated it. And I thought, that's just clear.
And I just want to say, because in case it is not clear to everyone who's listening, and I'm not just saying this because you're here. I mean, for a prosecutor, this is like a heroic thing that you did. And as negative as it is that in this case, there wasn't justice in the end for Helena, I hope that so many prosecutors around the country saw what you did and will emulate you and how they conduct their affairs, so they're never in your position, number one, because they've turned over the evidence, so that we don't see injustices in other cases, both defendants who aren't getting the evidence they deserve and victims who aren't getting justice because of mistakes prosecutors made. So I want to salute you for what you did. And in such a high profile case, it'd be one thing if this was a case, there's one person in the gallery and you're having to make this decision, but doing that under that immense pressure, it is very difficult for me to express how hard that must have been and how absolutely amazing it is that you did it. And I commend you for it without reservation.
Thank you. And I appreciate that. And I've always, and I always have said this, even as a defense lawyer, prosecutors, are the ones who do right, are the good guys. Prosecutors are the ones with the white hats. Prosecutors are the ones who go in there and you expect, and law enforcement, they're the ones who do the right thing. Our clients are the ones, who are breaking the law. And so I expect that law enforcement are going to play by the rules. They're not going to push that constitutional envelope to get that arrest, and they're not going to violate somebody's constitutional rights. If they do a traffic stop and they get 20 pounds of methamphetamine, but they did it violating somebody's constitutional rights, get the meth off the streets and let that person walk, they'll probably get arrested again down the line. That's just the reality. And you do it right the next time. And so that's always been my belief. And I believe that as a criminal defense lawyer, that prosecutors are the good guys, and not that we're the bad guys, but prosecutors play by the rules and are required to play by the rules, and full disclosure. And I just, when I saw that didn't happen, it was not right. So I couldn't be associated with that. I had to walk away.
And I am so heartened because I know that that same moral compass that you've described is how you practice criminal defense as well. And, we always say this, that you need zealous advocacy on both sides. So I'm so heartened to hear that. And you are right. For me, there's no divide between like the personal morality and professional morality. They're all one and the same. And, you mentioned at the very beginning that you were planning on winding down your practice when you took on this simple, surely, no one's going to watch it sort of case. What do you have planned next?
I actually want to wind down my practice because I'll be honest, I've received a lot of very nasty emails and text messages from both sides, and that's not the reason, but I would like to do something different. I love to write. I want to maybe write, not about this case. I have other cases. I would like to write fiction, but based on some of the cases I've handled cartel related cases. And, so that's what I think I want to do. And just, it's been a great run. I love the law. I love the practice, but, this was so disheartening, and maybe I'll change my mind in a few months, that I just don't know if I'm going to finish out the cases that I have. And I have a few cases left. I don't have very many. So probably just start writing. I don't know if I'll make a living. My husband better support me.
Well, I am so sorry to hear that you've been getting such nasty texts and comments from people. This is what happens when you are put in positions of high profile nature, which you have been, and you handled yourself with utter grace. And as many negative comments as you are getting, and we are no stranger to those, we get plenty of those ourselves in our professional life as well as in our podcast lives. They may be loud, but they certainly aren't the majority, because I will tell you, all of our fellow attorneys, whether they're prosecutors or defense attorneys, all gasped in utter amazement at what you did, because it is a position that none of us hopes to be in, and all of us hope that we will do the right thing like you did if ever faced with that decision. And you took that incredibly brave step to show all of us that there's only one step to take, and that is the right step, to follow your moral compass. So I hope you don't let any of those negative voices get you down, because my hope is that you continue to practice law. We need voices like yours in the courtroom. And if you choose not to do that, please come on our podcast and speak from the defense perspective or the prosecution perspective, because Erlinda, you have a wealth of experience, but more importantly, it all comes from the right place. It's incredibly principled. And this day and age, law enforcement and our judicial system and our criminal justice system is really getting a beating in terms of whether people trust it, whether they think it's the entire system should just be torn down. My position is no. My position is that it needs good people. Certainly it needs good people, and it needs good voices in there. And there certainly are loud voices and loud actors in this field who are not driven by principle. So as a personal appeal, I hope that your voice continues to be heard, whether in representing people or as legal commentary, because your voice is needed. And I feel very, very encouraged by your example.
Thank you. I appreciate that. I really do. Yeah. I come from a country that is now a dictatorship. It was communist. Now it's a dictatorship. People are imprisoned just for expressing oppositional views to the government. So that, to me, the law is very dear and near to my heart, whether it's that government overreach and prosecutors not doing the right thing and making sure that individuals have zealous advocates, individuals who are charged with crimes. And so to me, just making the right decisions, whether it's as a criminal defense lawyer, and sometimes, we know, and especially in the federal system, the deck is stacked against the defendants, but, we expect that we're going to have a fair and level playing field. And so I love the criminal justice system in this country. It's the best I think we have in the world. It's not perfect, but I think that we could end up with a system like the one in my homeland. And let me tell you, that's terrifying. It is absolutely terrifying.
I think that's a story you need to write down.
And let me say this, whenever you do write that book, you got to come back on and talk about it. We want to have you back.
Okay.
That book out there. It's
I'm on the second paragraph.
Hey, got to start somewhere.
Yep. You never finish if you don't start.
That's right. That's right. Well, I mean, truthfully, thank you so much for walking us through, your background all the way through this case, which I know is still incredibly fresh and probably still has many open wounds. But thank you for being so raw with us and for sharing your story. And like I said, I really hope we hear a lot more of your voice in all types of mediums, because our justice system will be better for it. But is there anything else you'd like to add, either about this case or last words of wisdom? You've already given us so many words of wisdom.
I don't know about last words of wisdom, but I just appreciate you guys having me on, and it's great you guys have this podcast. I think it's important because, especially in today's society, I mean, we need people to trust in the system, but we also need the people who work in the system to be honorable and to do the right thing. And sometimes doing the right thing isn't necessarily getting justice for a victim or a conviction. Sometimes doing the right thing is dismissing a case. And so it's great to know that there are folks like you and Brett. It's good to know that you're still on that on the prosecution side, and Alice, welcome to the dark side.
The dark side, indeed. Hey, if you're on the same side, then I count myself in great company.
Well, thank you guys for having me. I appreciate it.
All right. Well, guys, this has been just an utter treat for, I know, me and Brett, and I hope for you as well. We are so just thrilled for Erlinda and also for her to be able to share her story here. If you have any questions, please reach out on social media or at prosecutorspod@gmail.com. But until next time, I'm Alice.
And I'm Brett.
I'm Erlinda.
And this is the Prosecutor's Legal Booth. do a sign off, and we're gonna go, I'm Alice, I'm Brett, and you can say I'm Erlinda, so that we can close out. Is that okay? Are you okay with being part of our closing?
Yes, sure.
Okay, people are gonna pump their fists, when you say it. So thank you, Erlinda. That was incredible. Thank you. Sorry to give you the third degree, but when you give like other when you're interviewed on like mainstream TV, I guess they just skip over all the stuff that I actually care about.
I know.
I'm like, no, how did it happen?
Right.
I know. They're like the little sound bites. I'm like, oh, wait.
They did.
Right.
Thank you guys. Appreciate it. Keep up the good work.
Thank you so much.